Perfect. Well, welcome everyone. Hello, my name is Prashasti, and you probably know me from the emails that I've sent. Just as a heads up, we do have one more panelist who will be joining us a couple minutes later. So we're still in great company. But welcome and thank you so much for joining us today on Valentine's Day. And I'm once again reminded of Bell Hooks's powerful work and words on how without justice, there is no love. So I'm really thrilled to celebrate love today by welcoming our fantastic group of panelists today who will lead us into a discussion on immigration and criminalization as part of the Immigration and Scholar series. Immigration and is a new justice-oriented program that is open to everyone. So I'll drop a link in the chat and hopefully you've had a chance to look over some of our materials. But today's space is a space of reflection and hopefully some imagination. So we will start today with welcoming our panelists and then be in conversation with them for about 50 minutes. And then we will end with some resources that I'll also send in a follow-up email. So don't worry about that. With that, I'll hand it over to the incredible Zhina, who is a staff editor on the Georgetown Immigration Law Journal, and will be moderating our discussion today.
Thank you, Prashasti. All right, so I'm going to invite our panelists to introduce themselves. We're going to keep it to about a minute, and while we do that, Prashasti is going to be dropping links of their bios. If you want more information, please check those out. So we'll go ahead and get started with Julie Mao.
Hey y'all, my name is Julie Mao. I use she, her pronouns. I work at a legal movement organization called Just Futures Law. Already chatted the link over there. And yeah, I think just quickly, I think part of the reason why we were invited into this space was to kind of bring forward some of our work around policing, tech surveillance, and immigration enforcement. We really work at that intersection of both the criminal legal system, immigrant rights, as well as privacy and consumer law, and have been working at that intersection to sort of challenge the tech-based enforcement that is happening, and so much of the tech companies being involved in creating the mass deportation and detention system. I will just quickly also say and give a plug also to movement lawyering. I myself am a practicing lawyer of about 10 years now, and I think really was supported and taught in the pedagogy of movement lawyering and doing grassroots support work. So our office is certainly founded on those values. And I will pass it to whoever wants to go next.
Thanks so much, Julie. We'll pass it to Naomi Paik.
Hi, everyone. My name is Naomi Paik. I am an associate professor of criminology, law and justice and global Asian studies at the University of Illinois at Chicago. I also recently wrote a book called Bans, Walls, Raids, Sanctuary, Understanding U.S. Immigration for the 21st Century, which calls for a radical abolitionist sanctuary movement. So I'll leave it there. Thank you.
Thank you, Naomi. And I'll pass it to Talia Peleg.
Hi, I'm Talia. I am the co-director of the Immigrant and Non-Citizen Rights Clinic at CUNY Law School. And in that role, we represent immigrants in individual immigration cases as well as in federal court who are particularly vulnerable, both through their context in the criminal legal system, and also we work on a lot of cases of individuals who have been targeted by the national security apparatus. So we really are trying to push against a lot of the systems we're going to talk about today, and how those who we represent are particularly vulnerable to enforcement due to their positionality, both due to their race, religion, and other factors we'll talk about today. In addition, our clinic, we also represent, in addition to the direct representation of individual cases, we also support organizations through sort of what Julie was talking about, the movement lawyering, and really trying to support a number of community-based organizations in a breadth of projects, trying to push forward really outside of the current existing structures of the immigration law. And that work is really creative and interesting and generative. And I hope we definitely will touch upon it a little today. And I'm looking forward to sharing that with you. Before I taught at CUNY, I was an attorney at Brooklyn Defender Services, and I was the supervising attorney. And most relevant there was work I did to help establish the New York Immigrant Family Unity Project, NIFUP. It's still hard for me to say, but basically, which was the first in the country assigned counsel program for detained immigrants in New York that's now expanded to other places. But, you know, really looking at, and my scholarship and work kind of focuses on the intersection of criminal and immigration law, and looking forward to sharing more of that with you today. And I just really want to thank the Journal for putting this on. And also it's been, you know, just this series is incredible. And I really admire the work of the Journal. And I'm really excited to have recently published a piece with all of you. And it's been a tremendous experience to work with everyone. So looking forward to your questions and thoughts today. Thanks.
Thanks so much, Talia. And then finally, Sirine Shebaya.
Hi, everyone, and thank you so much for hosting this wonderful conversation. I'm so glad to be here with all of you and with my wonderful co-panelists. My name is Sirine Shebaya. I'm the Executive Director of the National Immigration Project. And we are a national organization that is basically a membership organization that also does its own advocacy, litigation, public education, and other work. So we have sort of two core sides to our work. One is focused on our membership, which includes legal organizations, private attorneys, community organizations, advocates, people with direct experience of detention and deportation. And in the work that we do with our membership, I think our orientation and focus is always towards lifting up the voices of people who are themselves impacted by the issues that we work on, and also giving attorneys the tools that they need, like the concrete, technical, actual tools that they need to really fight ferociously from this deportation machine that attacks our communities. And so our trainings and our CLEs and et cetera are a little different, I think, than what you would expect when you join them. You will see a very different orientation towards the litigation and immigration court. You'll see a very different orientation towards, you know, advocating for your clients and the people that you work with, and seeing the people that you represent as strategic partners, as opposed to, you know, clients in the sort of more traditional sense that, you know, attorneys tend to think about. And for us, that is really a concrete way of manifesting our commitment to abolition of these systems that oppress the people in our communities and the people that we work with. Our organization is also, for the first time in its history, led by first-generation immigrant of color, and our program staff is actually includes several people who came to the US as adults and had experience with the immigration system themselves. And so I think we bring very uniquely to this work, like a very deep personal understanding of the ways that the immigration system plays out, you know, for people, while also recognizing the privilege of our position as immigrants versus a lot of the people who come here trying to join this community and who are faced with all the horrors that we all see. We very unapologetically focus on issues at the intersection of the criminal and immigration legal system. We work on enforcement, we work on crim, we work on anything that has to do with people being criminalized by the systems, and we do that showing up both in DC spaces and in field spaces, which we're able to do because we're a membership organization with, you know, reach in across, I think now 49 states. So that, you know, without further ado, I'll turn it back to the moderator who will tell us what we're doing next.
Okay, thank you so much. Okay, so we're gonna go ahead and get started with questions. The questions are long and they have many subparts, so please feel free to address, you know, any part of it that really speaks to you. So our first question is, so we wanted to begin today's discussion by spending some time exposing the particular criminalization of immigrants. So what are the different mechanisms in which immigrant criminalization takes place, and what purpose does it serve? In that same vein, why is detention classified as different from incarceration, and how is that harmful? I'm gonna open it to the panelists.
Okay, I'll jump in. Sorry, I'm so uncomfortable with silences. First of all, I want to say big ups for having an all-women panel with mostly women of color. So thank you for doing that. So I think there's a couple of ways to think about this, and I know that my co-panelists, as people who are in the practice right now, my perspective might be a little bit different because I'm have the luxury of being an academic. But I just want to think about this a little bit more historically and think about how the very origins of our immigration restriction regimes are rooted in racism, sexism, and capitalism. And that has always been the case since the late 19th century, all the way up to the present. And as the contradictions of global capitalism become more severe, what we see is the reaction in immigration enforcement regimes also becoming more severe. Right. So as capitalism has become more entrenched globally, as we have more free trade agreements, as we have more of an integrated global market, so we have like a borderless open borders world for capital and goods, but we have a closing down and a lockdown on the movement of people. And so as global capitalism displaces people from where they already live, wherever it is, rural Mexico, India, wherever, Africa, all these different places, as we displace other people from their world, or from their homes, like through resource extraction, climate change, basically expropriating them from their lands and everything, then we're going to see more and more people having to move in order to survive. And in response to that, we lock down our borders. And so thinking about more recent iterations of that, we can think about the criminalization of unauthorized border crossing at the US-Mexico border as kind of like an example of this, right? So this starts in 1929 during the most revanchist kind of tribal 20s, where we had, rampant xenophobia, anti-Black racism, all of these things. And that's when we see the first time the criminalization of unauthorized border crossing, not unauthorized presence, because capitalists and business owners needed undocumented labor in order to exploit for greater profits. So the presence was never criminalized, but the crossing of the border without inspection is what gets criminalized. So that way you have this massive unauthorized labor source, right, which is good for capitalism. And you also have this mechanism to deport and detain and get rid of people when they're no longer useful, right? And so we see that in the 1920s. We see it really really become amplified in the more recent era, like especially after the passing of NAFTA, right? So the passage of NAFTA led to 1.3 million Mexican farm workers losing their jobs and their land. So of course, many of them turn to migration. And that's when we see the escalation of border enforcement with prevention through deterrence. So sealing off the high traffic border points or crossing points between the US and Mexico, like around San Diego, around El Paso, et cetera, and then funneling them into dangerous areas like the Sonoran Desert, where they knew that migrants were going to try to make the crossing anyway and would suffer and die in the process. And they thought that those dead bodies would deter future migrants from coming, which of course has never been the case. I'm going to stop there because I feel like I'm talking too long. I would love to hear from the other co-panelists.
I mean, I guess I'm not a historian. I also don't like silences, so I will jump in to sort of like add my 2 cents as someone who really comes at this from practice and from, the kind of, from the experience of actually having worked not just in the immigrant rights space kind of squarely, but also in the broader civil rights movement and with alongside and with and as part of many communities that have been sort of targeted successively by the immigration system. That, like, to me, when I kind of step back and look at the history of our immigration system, it is a history of successive racist enactments that are targeted at one group after another. Like, there is no part of the immigration legal system or of the immigration enforcement system that was not set up in order to target people and to shut them out based on their race or religion or national origin or some other of these spurious categories. And at each moment in history, you see the kind of geopolitical circumstances that are happening, and you see the targeting of a particular group, like Japanese Americans, Chinese Americans before that. You see the kind of, the migrant prosecutions that Naomi was just alluding to as a way of controlling movement from certain parts of the world and not from other parts of the world to come to the United States because of this vision, this kind of white supremacist vision of what the real makeup of real Americans who actually belong here should look like. And that's just something that I think really infects every part of our immigration system now and makes it really not possible to talk about reforms to the immigration system as though somehow you could erase the stain of that history just by like making some changes around the edges or fixing like, you know, whatever the problem is in the system or getting, I mean, you know, I think we definitely support some of these changes like, you know, access to counsel and all of that. But I just think that like fundamentally, we're very, very mistaken if we think that that history is going to be fixed by giving people an attorney in immigration court, because that is never going to be sufficient. And actually every part of the enforcement structure is built on that history, whether it's the way that people are put in cages for the duration of their immigration proceedings, or whether it's the way that people are treated when they try to cross the border, or whether it's the language that we use when we talk about people who are trying to come to the United States for one reason or another, or just fundamentally the assumption that the system takes that human movement is somehow unnatural or something to be controlled, or something that is not fundamentally related to actions that, you know, the United States is taking in addition to various other powers across the world who control people's lives without giving people the appropriate amount of, you know, say in what happens to their own circumstances. And so, not a historian, so this is not a very academic sort of telling of that story, but I just kind of wanted to emphasize that, like, if the history of immigration laws in the United States and immigration enforcement systems in the United States can really best be understood when you think about it as successive racist enactments of ways to shut people out and then to control them and control their movement, you know, for the sake of a vision of the United States that is fundamentally about white supremacy.
Thank you to my two co-panelists, and I'll add there, I'm also not a historian, but as sort of a law professor coming at this a little bit, I'll say that, you know, I think the law really is the first mechanism that we have to look at to understand the modern current criminalization of immigrants, right? So, you know, as my co-panelist said, you know, to understand the current system, we really, you know, I think the framing that we're all kind of bringing to this, that the immigration system from moment one has been rooted in exclusion and designed around excluding who is undesirable at a certain moment, and that has shifted over time. But I really want to underscore what my co-panelist said, is that it's always been race-based exclusion, and historically it was explicit, right? So I want to just say how we got to where we are now, right? Where, I'm sorry, my internet connection, can everyone hear me? It just told me it's unstable,
Yes,
so let me know.
hear you.
Okay, thank you. So essentially, quota systems that we've all heard about regarding who can enter, that was rooted in and based in eugenics, used to prioritize certain groups to promote white migration, to promote white supremacy at the core fabric of the US foundation and law, and other policies, right? That in order, for example, to naturalize, someone had to prove that they were white up until 1952. And we see the ways that the courts have grappled with this. But over time, as sort of these race-based exclusion explicitly kind of fall out of favor, what we see is a real shift to bring us where we are today in the 1980s and 90s, a real merger between the criminal and immigration system and this idea of crimmigration that Professor Juliet Stumpf kind of coined, where we see the race-based policies, explicit race-based policies, replaced with this idea of mass criminalization, right? And Congress vastly expands these criminal grounds of removal that are used both to deport certain groups of immigrants, but also to block others from entry or from gaining status. And the very same criminal grounds are used to suddenly say certain people need to be put in immigration jails, immigration imprisonment, and in some cases subject to mandatory imprisonment, where you cannot get out of jail for extremely minor contacts with the criminal legal system. And that's the system that we're in today. So that system came to really replace the prior, you know, explicit race-based exclusions. And so this merger has led to skyrocketing rates of detention and deportation in immigrant communities, with a disparate impact on communities of color, particularly Black and Brown immigrants. And Professor Alina Das writes a lot about this in her work. And so really, you know, to underscore what, you know, was said, is that the system functions in a way to exclude Black and Brown migrants to perpetuate this vision of white migration and a white immigration system, particularly harming Black immigrants who are facing detention and deportation at much higher exponential rates due to the focus in the criminal legal system of racist policing and racial profiling. And so then we see, you know, this sort of compounded effect of those who end up in the immigration system facing double punishment. And that's really what is really important to talk about. And I know I'm talking for a long time. I just wanted to add one point on the question about detention that you posed here, and sort of, just to turn to this one before I turn it over to Julie, is this idea of, how is it harmful that detention being classified as, not incarceration? Detention is coined to be a civil system. And I think for two reasons why the deep harm that we need to understand and start unpacking, that really permits this shadow jail system to exist around the country, right? Immigration detention operates where people are transferred all over the country. There's no guarantee you'll stay in a specific region. It's incredibly opaque. Even as counsel, it's extremely difficult to locate your client, let alone have any sense of what's going on or locate those you love who may be in these jails. People are shackled. And I know many of you know this, but just to really, the way in which people are treated in these situations, it really is imprisonment, and our language is critical around that, right? Why do we not call it imprisonment? I think to really hide what's being done, that this is a punishment, this is double punishment, and being used to really reinforce some of the things that we were talking about earlier. And because it's sort of a civil system, many of the protections that run to the criminal legal system, although albeit very insufficient there, right, but do not run. For example, no right to counsel, which you heard about if you're in immigration detention. We know those who are in immigration jails are way more likely to lose their immigration cases, are way more likely to agree to their own deportation due to the conditions of confinement. We know of horrible medical neglect, abhorrent medical conditions, which some of my colleagues here have litigated and brought to the surface extremely powerfully. So these are all of this, it being a civil system leads to very, very real consequences on the ground where people agree to their own deportation. And I really think it continues to serve this purpose of removing those who are deemed to be undesirable and classified as such, and continuing sort of an immigration system rooted in promoting white migration and leading this pipeline for Black and brown immigrants to be sent away. Sorry, that was long, but thank you.
I mean, I'll just add like plus to what everyone's saying. And I think we can go to the next question, but I just think, what everyone was saying was so on point around the history, and especially the sort of operationalization of the current, structure of like it actually being about a carceral system that is stamped as civil in order for it to have even less civil rights and constitutional protections, and that it was not unintentional, but an intentional structure that is rooted in a lot of the social and race and ethnic control in the US.
Can I add one more thing? Sorry, just to jump off of what Talia was saying. The only way that it makes sense to think of migrant detention as a civil system, whereas like it's a totally different thing than criminal legal system, is if you prioritize legal categories and the viewpoint of the state and not the viewpoint of the person who is actually enduring inside, right? So from the experience of the person enduring inside, you have the same kind of uniform, you're held in the same kind of space, you still have the same kind of social control, you are subjected to the same kinds of abuse. So from a qualitative experience of the person in detention or in incarceration, the experience is the same. And so I think one of the things that I think all of us are trying to get at is that we need to kind of distance ourselves, divorce ourselves from the viewpoint of the state, which means relinquishing some kind of, I know for a lawyer, you can't do that because you're working through the system, but there has to be some kind of resistance to drawing on the categories, right, of the state, right? So civil detention is one thing, criminal detention is another thing. Refugees are different from migrants, et cetera, et cetera. And we need to center what is happening to the person instead. So that's it.
Thank you so much for that addition as well. And thanks everyone for the discussion. So moving to our second question, there's a lot of discourse on alternatives to detention as a solution to rectify the harms posed by detention. Can you elaborate on how the prison industry has co-opted the term alternatives to detention and how these programs operate? What are the pitfalls of relying on these reformist reforms that still operate within the carceral apparatus? And Julie, I would like to start with you on this question.
I love these robust questions. I feel like clearly y'all have been thinking about this for, a bit of time, and just shows how prepared you guys for these panels. So I'm also very curious about the viewpoints of the participants. So I think what I would do here is kind of set a foundation about what we're talking about, and then maybe get to some of these pitfalls or co-optations that y'all have referenced. But I thought maybe I could sort of lay a background around what is the current sort of ICE alternative to detention program. So the main one that's operational within Department of Homeland Security is one that it's operated by Immigration and Customs Enforcement. And they call this program ISAP, or also termed Intensive Supervision Appearance Program. So not a very alternative-y sounding name. Certainly, even the name itself discloses just what their sort of purpose and goals are. And so this supervision program, the current numbers are about 167,000 individuals in the program itself, which actually makes it, when we did the research a couple months ago, makes it one of the largest, if not the largest, supervision program by any law enforcement office in the US, if not in the world. Like 167,000 individuals is a lot of people. And so much of immigration is like so many stats and big numbers, and we tend to dehumanize even one person, right? But like just thinking about that level of individuals right now at any given time in the supervision program. And then even last week, I'll chat in the news article, the Biden administration announced that it was going to surge the ISAP program and try to enroll about 400,000 individuals by the end of the year. So again, these are incredible numbers, and kind of shows just how massive these programs are. The current contract that ISAP is under is with the private prison company BI Incorporated, which is a subsidiary of GEO Group, which is very much known for contracting private prison detention centers with ICE. And that contract is for $2 billion, about $2.2 billion over 5 years. And I will say, we all have criticized, many of us have criticized the Trump administration's Immigration Customs Enforcement Agency. It's been really stark to see that ISAP has certainly grown far more under the Biden administration. The numbers were around 80 to 90,000 individuals just early last year. And now they're at 167,000. So I think we can really expect that they will reach that 400,000 individual number, if not by the end of the year, certainly by next year. And so, like you were saying, what does this program look like? We're talking ankle shackles or GPS monitoring technology that it fixes to individuals' legs, causing pain, causing long-term bruising, causing a lot of emotional distress, right? There's also the development of sort of cutting edge other surveillance technologies like voice recognition. Telephonic has been one that's been going on for a decade or more now. And then the largest group of individuals are now enrolled in a mobile phone application called SmartLink. This is also provided by BI Incorporated. It uses facial recognition and constant mobile location services to monitor individuals who are on the program. And we really see this at Just Futures as an extension and expansion of the carceral system. These are punitive measures, right? They are used to maintain control over people's movements. They're very punitive, surveillance and threat-based. If you do not comply, you are re-detained. And I think this is kind of where I kind of want to point out some of the pitfalls of reformist reforms. When we originally saw the ISAP program or alternatives to detention be marketed, it was really fed to Congress and advocates as a replacement of detention, that somehow it would reduce the detention numbers. But what we've seen, and people were very much like trying to buy that, like, okay, it's going to be more humane, it's going to reduce numbers. But we've actually seen in the data that the overall numbers in detention have grown, simultaneously alongside the vast expansion of ISAP. If you've been a practitioner for more than a decade, folks can remember, like in the early 2010s, 2008, 2009, we just didn't have that many clients on ankle shackles, right? Like it just wasn't a thing that people experienced to scale as the default. But now this is something that pretty much almost everyone who gets released at the border is under some sort of supervision. And so I think in the promotion and fight for this sort of alternative or release of detention, we've also created the expansion of a surveillance carceral program that is now, we have a state where we are both detaining more people as well as putting more people under ISAP. And I will say it is very much driven by the co-optation of these corporations. Geo Group both gains from one side of the prison system with the detention, and then the release of detention, they are paid per day, per ankle shackle or smart link that they have on a person. And you can certainly see in the materials to shareholders that the largest expansion of their, sort of capitalistic model is really in the pretrial probation and immigration services. And I think I'll leave it at that. The one thing that I will note, sort of stepping back and trying to be a little bit more academic, is that I think the alternative to detention program is, as ICE sees it, right, is so driven by the fundamental answer to the question, how do we treat people who migrate to the US? And the ICE's answer to that is that detention is the default. So anything that's the alternative to detention is going to look like detention. So I'll leave it at that. And I'm sure my co-panelists have other great insights to this question.
I mean, I guess I can jump in to kind of echoing all of the great things that Julie has said, and maybe adding one other point for people to sort of think about in this context, is that the problems with these alternatives to detention very much mirror things that happen in the criminal legal system too, in very parallel ways. So like when people say, well, it's great to have someone out on probation rather than inside a prison, what you're actually doing in that context, for example, is creating a whole new set of reasons to put someone in jail again for technical violations or whatever. And when you think about something like the ISAP system from that perspective, it also looks very clearly like, the alternative actually would have been to not have people surveilled or detained. But because the primary framework is detention, what you're doing is now you're saying, okay, this isn't detention, this is something else. So let's add like 400,000 people to it. And now those 400,000 people are going to be at risk of detention at any moment because, their ankle monitor doesn't charge or something happens. So like, not only is it in its own right, like grossly inhumane and also frankly kind of disgusting to be like, putting people in this kind of surveillance state, but also you are actively putting more people at risk of detention than would have been if you had no program that was ISAP or ISAP related. And so like really kind of when you think about what the alternatives are, it's not detention versus these programs, it's actually detention plus these programs that lead to more detention versus like taking a step back and thinking about why it is that we have all of these structures to begin with to put people in prisons and jails when they're coming here to pursue lives that are full and robust and include participating in communities and like just all of the reasons why people might move that really should be viewed as something very basic and fundamental and that will always happen. That is something that should be sort of like par for the course, as opposed to this like awful thing where every time anything happens, people get scared about like what the narrative is at the border or what else, because everyone has been so like taken up by this narrative that somehow having people moving is itself like something to be really scared about. And so, I think that these structures on alternatives to detention are just a continuation of the other structures that like sort of flow from that assumption.
Yeah, I really appreciate, Julie, your comments and your very clear breakdown of what is actually happening like on the ground, right? So I really appreciate that breakdown. I think the $2 billion contract is unsurprising, and also, I don't know, it's bringing out stuff for me. So I just put a link in the chat to an article by Mariam Kaba, who is an abolitionist organizer. And it's just a kind of guideline about police reforms. And, ICE is a policing agency, CBP isn't a policing agency. Just because they're under different kinds of departments, they're still cops, right? Okay, so police reforms you should always oppose. But basically any kind of reform that is leading to the expansion of the size or the scope or the duration of any aspect of the carceral state should be opposed. So in this case, ISAP is claiming to be as a kinder, gentler, like more free version of whatever detention would be, right? But what it's actually doing is just expanding the size and scope and mechanisms of the carceral state. And it's also doing so by basically feeding into a new market, right? Like this is the shareholder report was very elucidating because they are seeing this as a growth area. So border enforcement, camp detention, these kinds of virtual or electronic forms of surveillance and social control. This is a growth area for the very parts of the economy that we want to abolish altogether. I mean, we'd like to abolish capitalism altogether, but these areas in particular, we want to abolish altogether. And then anything that is considered an alternative to detention, the alternative to detention is to not to detain people at all, but to put them in their communities, to give them kinds of services, to integrate them into like having their kids in school, getting them jobs, things like that. If you want to think about if the reason for putting migrants in detention is to make sure that they show up to court, the alternative is to integrate them into their communities, right? That has more of a motivating factor of getting people to show up for detention, because they don't want to, once you're embedded in a community, you don't necessarily want to leave it. So there's like grassroots leadership has talked a lot about this as its alternative to detention. The alternative to detention is no detention, no social control, right? I think also, I'm going to dump this other book in the chat. So James Kilgore also just wrote this fantastic book called Understanding E-Carceration, which I'm finding very helpful because I don't understand technology. And so I think his kind of just like kind of very, very approachable kind of explanation of what is e-carceration is very useful. Because I think one of the most dangerous things about e-carceration is that people like me, like I have a digital surveillance device in my pocket at all times, but I don't really understand how it works, right? And I think that this Biden program with 400,000 new individuals is part of the kind of invisibilization of the expansion of the carceral state. And because we don't understand it, we don't know how to effectively kind of combat it, or at least I don't. I think Julie has a better sense of this, but, and we don't know how to turn these digital surveillance devices against themselves, right? So like, I think, for example, the George Floyd recording of his murder is a way of like taking this digital surveillance device and turning it against itself. But I feel like I personally need to have a deeper handle on how this all actually works, and what are the different connections between these different kinds of corporations, the different kinds of technologies, and the mechanisms of the state in order to effectively combat it. Because I feel like it just feels very overwhelming and scary, and I don't really understand it. So I'm really appreciative of people like Julie to help me understand like where can we actually intervene, right?
Talia, did you want to jump in on this question, or should we move to the next one?
I don't have anything to add, but
Okay.
Thank you. Yeah.
Okay, no problem. Okay, so our final question, what do you think are the essential and actionable tools for disrupting the criminalization of immigrants and the carceral apparatus as a whole? How do you envision this work from everyone and lawyers who uphold this criminalization with the neoliberal good versus bad immigrant rhetoric? And Talia, I'd like to start with you on this question.
Great, thanks. So I think the first step is sort of reflecting on the immigration context, what we touched on kind of earlier and what we're hearing now, and sort of introspection that I think lawyers and law students, those of us that are here, many of us that are here really need to do it to start as the first tool of thinking of something different or moving forward, right? I think being very clear on the history of the modern immigration system, as Professor Michelle Alexander says, the politics of white supremacy engender new systems of racial and social control over time, and seeing and understanding how this has worked under the modern immigration system, how the deportation and detention system works as a system of racial and social control, as Sirine was talking about, helps us make our understanding of the law, what it is we're doing, both more accurate and realistic, right? Like we just heard, being honest about what the system is doing, as we just heard in the last comments on sort of the surveillance and, supposed alternatives to detention. What is this really serving? That introspection is key to start. And from there, it's really important to understand how the law is used to uphold this social control, right? Is a mechanism of social control to perpetuate the system. The law is meant to uphold the structures of white supremacy. And so in order to understand what our job is as lawyers, the law itself will not liberate us. And of course, many have written on this, many have spoken about this, but as lawyers, doing that deep introspection to start, I think is important to even imagine moving away from any sort of carceral system. Right. So understanding how we as lawyers, law students are, the law itself is a very conservative tool. Again, I'm not saying it can't move towards some change, but is a very conservative tool and actually is designed to uphold what is, I think is key to start the work, right? Or to start to think about where we fit in as lawyers. So that being said, and other people have talked about this, really this idea of movement lawyering that we started with, right? Figuring out if I think most of us here would agree, or at least I'll say that I agree, and I'm starting from this premise that community-led work by those who are, directly impacted is really what is needed to create sort of large change, social, imagining a different reality that invests in people's well-being versus investing in a carceral vision, right? This different vision, this abolitionist mindset. If we agree that in order for that to really happen, it needs to be led from the ground up. So then I think it's really for lawyers to think about, and this is this idea of movement lawyering, who many have written on and many here, Sirine was talking about the work the National Immigration Project does on this, and Just Future, does this work day in and day out. So you can see some really great examples. But lawyers have to figure out, how do we support the work of movements? And that, I think that's a place to start. And we really don't need to start from scratch. I think there's really great examples, but also there are many immigrant rights organizations now who are making abolitionist demands, particularly since 2020. Numerous organizations have kind of, Sirine was talking about the reforms on the policies, harmful policies on the criminal side. There's been a lot of work done, abolitionist work towards anti-prison work for many, many years, much longer than in the immigration space. But there's been a lot of collaboration and partnerships that have been growing. And I think we as lawyers need to see how can we support that, right? And I think key though is listening and kind of being in spaces and listening to what needs to be done, but understanding our role. And I don't want people to, I know there's a lot of law students here. I don't want you to walk away thinking that there's no place for lawyers. I think there really is, but it's listening and understanding how we can use our tools, our ability to manipulate and push the law in advancement of some of these principles that organizations and organizers and directly impacted people who are suffering at the intersection of these systems want to see done. So there's a lot of work being done. There's a lot of places to plug in. And I think using our skills and power as lawyers and recognizing we do have power and the tools that we do have can push in certain ways. So I think being very intentional as lawyers in the work you do and the support work, and I know it's hard when you're in practice too, especially if you're in direct services, which was my background before being a professor, but finding space to support movement work, both in your own personal life, but also through legal work. Like in our clinic right now, we're supporting a coalition here in New York and New Jersey, an Abolish ICE coalition that worked to pass legislation in New Jersey. And we've seen a number of immigration detention centers shut down here in New Jersey. And what we're able to do with our skills, what they've asked us to do is put together a report on both how that kind of came to be and the closing of the detention centers, but also being really clear about how that's insufficient, because what we're seeing is many people being transferred all over the country. And so we're able to use our skills. Our students are drafting a report that we hope will be used around the country for people to try to argue why immigration detention in it of itself and alternatives need to be eradicated and why that's problematic. So you do have skills as lawyers, you do have voice, you do have power that we've talked about. And I think being very intentional on how you use it to expose some of these things. So I wanted to say that, and I'll just say two other points. And I think, I personally think, fighting individual cases and representing individual clients is still a very, can be a tool also, okay? I think there's a lot of, and again, I come from a background of litigation, but I think thinking about how you use your lawyering skills to expose the ways in which the system operates as a means of racial and social control is really important. And, Naomi made this point, as lawyers, we are in the system and we are upholding the system. But I think you can think, and I think with my clinic students all the time in our cases, how can we try to resist the categorization? How can we try to resist what's being, how can we tell the story? Immigration law has valued throughout all time, this narrative of deserving versus undeserving immigrant. Who deserves to be here, who doesn't? Who is worthy of liberation and who isn't? And how do you litigate a case to really expose that? And, we worked on a case in our clinic where the legal issue was whether our client was admitted as a green card holder in the airport. And our students really made the litigation about why was he stopped in the airport as a Somali man, why Customs and Border Protection approached him and, racially and religiously profiled him, leading to his detention and potential losing of his green card. So I think how you frame your case theory, what you choose to litigate and how you litigate, again, is that going to completely change the system? No, I don't think so. But I think, again, part of abolition, right, is moving harm reduction, right? There's ways in which you can try to engage in the system. We're not going to overnight have a new system, right? And I think the ways in which you litigate, and again, understanding there's going to be an undeniable tension. You are representing someone in a deeply harmful system. You're an actor in that system. But what are the ways in which one can resist? And I think thinking through that thoughtfully as lawyers and law students does have meaning. And also, again, I just, in that case I talked about where our client really led a lot of our strategy, like how we were going to talk about what happened to him at the airport. And again, this is like client-centered lawyering, but there's multiple ways that you can try as a lawyer to both reflect on your role and act differently. And the last thing I think is, what do you do as an individual outside of the law, right? Like, I mean, I think, and this was like sort of part of the question too, it's not just what you do as a lawyer. And I know a lot of the engagement questions you all posed, which were great and so thoughtful, like, you're a member of the polity, those of you who can vote, right? Like, who are you voting for prosecutor? Who are you voting for your mayor? I'll say here in New York, those deeply, deeply impact immigrant communities, deeply impact ourselves. So I think looking at the work doing, and also, if you're, resisting calling the police and things like that, which I know a lot of you have thought about, but I know those are some of the questions you pose. There are ways, and I think we all need to be looking at how we're living our own individual lives and participating in our community that can try to move towards a different vision and a different reality, both in the law and in our society.
Thank you, Talia. Just plus all the stuff that you've said. And like, I just want to give kudos also to all the teachers in the space and academics who are just like doing the law and support of, intergenerational movement building with all the new lawyers that are joining our movement. I mean, I think for me, I would add like maybe two quick things. One is, we're talking about a federal, large, sort of expansive immigration system, but so much of that system is actually very controlled and influenced by local jurisdictions and policing and local jails. And so, I think the data is still very similar, where it's like, since the Trump administration, I think it's like still 60 to 70% of all individuals who enter the immigration detention system they are there because of some sort of local policing interaction or jail transfer or criminal history, right? Like so much, as Talia was saying, around like the 1996 laws or modern immigration detention system, mandatory detention, it is so driven by the local police, action like on your block and in your neighborhood, and the sheriff. Thank you. And as a DC resident, who we've worked with a lot of movements around ending the DC jail collaboration with ICE. I mean, it is so influenced the individuals who end up in detention or not. So I would say, that is a huge sort of intervention lever point, is the ability of local community and lawyers to draft policies and create accountability with local law enforcement. And then I think the second one, kind of alluding to what Naomi was talking about around corporations and their involvement with ICE and DHS. There is virtually almost no program now at DHS that is not initially built or exclusively built by a corporation or a consultant or a third-party vendor, right? Like ICE doesn't have the technology. They like to raid, they like to have their guns out. It is corporations and technology companies that are building their tech infrastructure. And that is how we are getting to sort of the mass scale of anything from detention logistics to and flights to raids and how they can locate individuals. And so, particularly for folks who are in law school, the role of LexisNexis and Thomson Reuters in doing huge data broker queries on individuals so that ICE can locate them at any given time and conduct raids. I mean, there is just a lot of involvement of tech giants in this deportation apparatus. And then I think lastly, going back to Talia's point about movement lawyering, I think a lot of lawyers are sold on the fact that they themselves can do it alone and champion justice. I think there's a longer conversation about why that individualism or neoliberalism exists in law school or in society generally. But, that is not how we're going to get change in the immigrant rights movement. We are up against so many different entrenched institutional barriers and structures. And so being able to work with community, knowing how to gain the trust of the community, and working with them for long-term change is going to be sort of the solution to any of these interventions.
Yeah, I'll just plus one to everything that everyone has said. But in terms of what Julia was just saying about local jurisdictions, I think this also highlights the importance of folks who are really invested in an abolitionist approach to migrant justice, that we have to get in and make the connections with the criminal legal system as well. And so the movements to abolish ICE should be aligned with movements to abolish the cops, right? And to think about the role of prosecutors, to think about, who is the sheriff? Like when I was living in Champaign, Illinois, which is a small community, the sheriff's race was actually kind of a cipher for thinking about immigration. Because because the sheriff controls the county jail, right? Which is where immigrants end up going when they are picked up on like a broken tail light or something like that, right? So these are really important. They seem like small things that the elections you don't pay attention to, but they actually make a qualitative difference in a community, which then makes a qualitative difference to people in that community, right? So I just want to kind of highlight that, like, the movements for criminal legal, the abolition of the criminal legal system and the movements for migrant justice have to be aligned. They cannot operate on separate tracks.
I guess I will also plus one to everything everyone said and maybe add a couple of sort of discrete thoughts about this. I mean, one of the thoughts is that I think a lot of supporting movement and being part of movement is also very concrete and like day to day. I feel like as lawyers, we have certain entitlements and privileges and experiences that we are able to use in one way or another. And so really actually just being willing to like roll up your sleeves and do the thing that needs to be done and then hand it over to people so that they can use it. Like that to me is actually itself like an act of subversion. Like, I think a lot of people are very, like there's like a lot of people who are in orientation kind of on the same page, but not everyone is equipped to really jump in and do the work. And I think for me, like that is something that I always tell myself. It's like, no matter what else is doing, we can actually jump in and do work that needs to be done and give it to people so that they can use it. And like, that is actually a way that lawyers can help where, they're not able to do other things that actually are more appropriately led by others and not by them and not by us, and so like, that is just a very concrete thing that I would like to sort of like, hand into the atmosphere, like never hesitate to jump in and do work that needs to be done when there's general convergence around the strategy and, everyone is aligned and everyone feels like, okay, there's something that needs to be moved forward. And, the other thing that I also kind of want to share in this space is like, I do think that like, there is a sense of entitlement that people sometimes don't have when they come here as not having been born here or grown up here or something like that. And I know that like from my own self, like, or from like, Muslim and Arab communities in the United States, for example, and the way that they relate to their own political orientation or their ability to like jump in and fight for things that they want. And I do think that the difference in how you grow up and your feelings of entitlement are just very, very fundamentally different. And for me, there was like a journey of coming to feel entitled to fight for a better system, which I just think is something that we need to really recognize when we're thinking about ourselves as lawyers, when we're thinking about the people we represent, like just in terms of individual cases, which I agree 1,000% with Talia, is something that can be very subversive. Like the way that you represent individual people in immigration court is something that could be fundamentally subversive. But like thinking about that in relation to how there isn't like a community, there are millions of different perspectives within communities of impacted people who are each like looking and striving and like listening to all of that and thinking about how you process that and how you relate to that and how like there are many different parts and everyone playing their part is actually part of moving forward the goals that we all have. I think all of those things are just really, really important to understanding like how you support people who have experienced the immigration system as something that has impacted them negatively and how you stand with communities that are trying to sort of sort out and figure out like, what is my ask or like, where am I actually, and kind of coming to feel a sense of entitlement to really jump in and fight. And to kind of like round out all of that, I actually do think that there is a way of thinking about lawyering in the kind of day-to-day of it that is very much about subverting the system and being as aggressive as you can be such that you can do what you can. I'm going to drop in the chat for any of you who are interested. This is like a longer form, like a more like a 5-minute or 10-minute kind of spiel on why I think attorneys should actually be trained in the tactics of like fighting in immigration court and other courts and look to other contexts, like for example, the criminal defense system and other defense systems, and like take inspiration from every place you can to really come into court as aggressively as you can, because that's actually a way that you can there's a way to tell stories that doesn't accept the law as it is, but just understands like there's a way to say I am working within these parameters because they are the only way for me to get a certain kind of relief for my client, but those parameters are mistaken and fundamentally problematic and racist and et cetera. And so just wanted to kind of also add that thought into the mix.
Thank you all so much. I know we're short on time, but just wanted to say thank you all so much for your time. I know as a current law student, it's these conversations that kind of keep me tethered to why I came to law school in the first place and what it's going to look like after. So I really, really, really appreciate your time, sharing all this with you, sharing all this with us. And I'm sure there's other students who are viewing this now that would completely agree with that as well. So thank you all so much. Thank you also to our co-sponsors. And for all of you guys who joined us today, we encourage everyone to continue these conversations amongst yourselves using our interactive syllabus and continue with us in next discussion on human rights, which will be on February 25th. And Prashasti is going to be following up with all the links that we shared today and some additional information about our panelists. So I hope you guys check that out and look out for that email. Thank you all so much for your time today.
Thank you.
Thank you, everyone.